Docket number SJC-13570, Commonwealth versus Renardo Williams, Jr.
Okay, Attorney Baylor.
Good morning. May it please the court, Jeffrey Baylor from Mr. Williams. First off, we contend here that Mr. Francois' statement should have been admitted without requiring Mr. Williams' testimony to show self-defense. Excuse me. Mr. Francois told police that at the time of the incident, he was carrying a handgun and said that it was in his pocket, and when he realized police were on the way, he threw it out. He also said that he and Mr. Cato were dealing drugs that day and looking to obtain more drugs to sell. We contend that the statement regarding the weapon should have been admitted. The drug evidence was admitted as a statement against penal interest. It was stipulated that Mr. Francois was unavailable at the time of trial, and clearly carrying a weapon would have implicated him into a gun possession and possession of a loaded weapon offense. The trial judge seemed to say that there was not enough evidence of self-defense to make this carrying a weapon relevant until Mr. Williams testified and said that he acted in self-defense.
No, or at least that he testified that he saw the gun. And why is that incorrect?
Because there was other evidence that was enough to show self-defense even without the testimony.
What was it? What was there before the defendant testified?
There was evidence that Cato and Francois drove up to meet Williams. He wasn't the one who started this. They drove him, and in the car was found drugs, a ski mask, money, and the evidence showed that the weapon was fired.
We don't know when, though, right? I mean, the weapon was fired at some point. We have no idea when it was fired.
Well, I mean, it seems to me that it would be logical that if it was, what happened was there was a jammed cartridge in the weapon. It seems like...
And the safety was on.
Right. But the jammed cartridge would likely have been cleared if it wasn't fired during this incident. I mean, otherwise Francois would have been carrying around a gun that has this jammed cartridge in it. So I contend that it's logical to believe that it was fired and fired at the time because it would have been cleared otherwise. And
even though we don't have any, okay, go ahead, sorry.
We have to think about the burden of proof in a case like this. That
I'm just trying to figure out what you would do if you got this statement in and you don't have anything else. Are you going to be able to build a self-defense?
Well, I mean, that's saying that it was fired, there was a drug deal going down. It's just as likely that they were going to rob Mr. Williams as he was going to do anything. And remember, it's the Commonwealth's burden of proof to show that self-defense didn't occur.
That's a trial. But to allow to get this is it's a different burden. It would be your burden, right? Was there a separate voir dire about this issue? So all of the evidence that you wanted to adduce, that aside from your client's testimony, to suggest that there is enough to get the self-defense instruction. Was there a separate voir dire done of this?
A voir dire with witnesses?
Whatever evidence the defense.
There was a motion in limine before trial about this, and then
was there evidence taken with the motion in limine?
There was not.
Okay.
I mean, it was just, here's what the situation is. The gun was found, and the judge saying there's not enough for self-defense without that. But there was argument about it. Plus, it was brought up several times during the trial saying, you know, we're going to bring up self-defense. This is forcing us to call Mr. Williams. And we contend that if Mr. Williams didn't testify, there's at least enough to justify the self-defense instruction based on the drug dealing, the weapon that was loaded. Oh, and the safety. Mr. Francois told police that he threw away the gun when he knew police were coming. So easily could have turned the safety on. But also, expert witness testified that,
He turned it on after he'd been shot 5 times, easily?
well, when he was well, I don't know how easily, but it could have been turned on. But also the expert testified that just throwing it from the car would have turned the safety on.
Could I just, because it's important to, I think, the resolution of this issue. If you're saying without the testimony of your client that whatever evidence was marshaled and outlined in that motion in limine, what is the burden of proof and who has it to demonstrate to the judge that you're entitled to this?
Well, okay, yeah, okay. I think it is the Williams burden of proof, but it's a very, very low burden. I quote the case in my brief.
Well, it's a preponderance of the evidence, wasn't it?
I imagine so, yes.
So if the trial judge now making a discretionary decision about it, the preliminarily whether or not he's entitled to get this is not convinced according to that low burden of proof, what is it that we are to do with that?
Find that there was enough.
But it would be an abuse of discretion standard, wouldn't it?
It would, well, it would be, yes.
Okay, so other than what's already in the motion, what else would the trial judge have prior to making the determination that, no, I need more, that you say should have convinced him to give it?
Well, I mean, the things that I've stated, those were talked about all, beginning with the motion, but all through trial, all the way up to the time when it was going to be whether Williams or not would testify. So the judge was still considering it, saying, I'm not going to admit this unless Williams testifies and shows that there's self-defense. So all along, evidence is coming in during the trial, and they're still talking about it. So everything that is presented, I mean, that I've talked about, the judge had to consider.
That's what I'm getting at. You're saying as the Commonwealth's case in chief is being put in, prior to their arresting and prior to now the defense has their opportunity and had to make this call. That's what I'm getting at. If you're saying there was something more than what was given pre-trial in the motion in limine, what is that? What is that happened during the course of the Commonwealth's case in chief?
These things that I mentioned, the drug dealing, the firing, were mentioned before the trial, but then it was all shown during the trial that what the situation was.
But it's the same stuff.
Same stuff. Yes.
Okay.
Yes.
Okay.
I thought there was evidence that that all of the I always get gun terminology mixed up, but the shells in the car were from were of a different caliber than the caliber of the gun that the victim threw out of the car. Is that correct?
Yes.
So how does the fact that, I mean, that seems to diminish the weight of this this gun, this second gun. And there doesn't seem to be really any support for the idea that the gun was fired during this episode.
Well, as I said, I believe that the GM cartridge shows that it was fired.
But wouldn't that bullet have gone somewhere?
Well, I mean, it was a parking lot, there was a dumpster, there was a
It was
fence.
inside a car.
It could have, well, the door was open. I mean, it could have gone anywhere.
But there also is the shot spotter only hears 40 caliber.
Right, and the experts testified that if there was a larger caliber gun going off, the shot spotter may well have not picked it up. Also, if it was in a car, shot spotter may well have not picked it up.
Okay, so all of that just seems to go to the fundamental question, which is, why couldn't the judge look at this and say that standing alone, what you've got would not merit a self-defense instruction. It's just too speculative.
Well, the judge could do that, but we're saying that based on this evidence, it was improper for him to do that. And the shells for the bigger gun found out outside, I think that's helpful to Mr. Williams because it shows that the second gun there was two guns involved. In other words, without Francois' testimony saying it was his gun, the Commonwealth couldn't argue that that was Mr. Williams' gun. So we know that there was at least two guns at the scene.
Can I just want to make sure, are you saying that I thought the argument was that the defendant saw the gun, not necessarily that the gun had been fired at him first?
He saw the gun and then panic ensued. He pulled out his gun and shot.
Can I switch you to some of the other issues?
Yes.
I don't want to lose you. So the intent to kill versus intent to murder point, just remind me the different element. There's no malice and intent to, what is the different element?
There's intent to kill is a lesser included offense of intent to murder.
Right. So how does it?
So there's a mitigating factors that have to be found, excessive force and self-defense, et cetera, to reduce it to intent to kill.
I'm just trying to, I'm tracing your you have three different issues. So
Right.
Francois, you say, was bending over according to your client, and therefore there may have been a mistaken belief that,
Right. K-Tor is the one.
excuse me, K-Tor is, so K-Tor is bending
Yes.
over. So there may have been a mistaken belief. And then you also say, well, that's maybe why they have only intent to kill rather than intent to murder.
Right, right. 'Cause the only difference between the two was the evidence showed that Francois had a gun. The evidence didn't show that K-Tor had a gun, but Mr. Williams testified that the gun was pointed at him. He saw K-Tor bending over, and he believed that K-Tor was coming up with a gun. So in self-defense, that's when
He's already shooting at Francois at this point, right? There's some, doesn't his testimony say he fires 3 or 4 bullets at Francois first, or am I misremembering?
I don't recall
By the way, is
that.
this some kind of automatic, I mean, is this one where,
Well, the gun was never found, so there was no evidence about what type of
okay.
weapon it actually was. But yeah, we contend that the self-defense instruction failed to follow the form and include portions that would have allowed the jury to find self-defense if they believed that Williams was mistaken as to K-Tor.
And mistaken about whether he could escape.
Right, that also. So there was 2 instructions that are part of the form, the model jury instructions. These instructions follow the
Are
model.
there any cases where because they're going to stand up and cite a couple of cases that say the failure to give these are covered by the more general earlier murder instruction. Are there any
Right.
cases that say the failure to give these to is reversible error?
Not that I came across, but I mean, it was important enough to have these instructions included in the model instructions so they could say that those were enough, but clearly when they're drafting the model instructions, they found that it wasn't enough. The 2 parts that were missing was after the first 2 elements.
Can I ask one other question
Sure.
factually? So when the jury comes back with this question about escape,
Yes,
are you trial counsel?
no.
Okay, what does trial counsel say? Does trial counsel insist that this instruction be given, or does trial counsel just sit pat? What happens
There was no request for these extra parts.
even after the jury comes back with this
Well,
escape question?
I don't recall his exact words, but the trial judge said he wasn't going to give anything additional with the self-defense instructions. So the 2 parts that were missing,
And at that time, the new instruction had been issued. our new murder instructions were out.
Yeah, these are the instructions that were current at the time.
So including those two.
Yes, yes. So we contend, I mean, I can read you exactly what was missing. A person may use deadly force to defend himself even if he had a mistaken belief that he was in immediate danger of serious bodily harm or death, provided that the defendant's mistaken belief was reasonable based on all the circumstances presented in the case.
So again, let's stick to these facts where the defense testifies that Francois is pointing a gun. He initiates this, right?
Right.
The defense testimony is that Francois points the gun at him and then he starts firing at him. Do we really have an issue here about mistake? I mean, his defense is they initiate the gun play here, right?
Well, the thing is that the evidence shows that Francois had a gun. Fine. The jury says
And he's pointing it at.
he's pointing at it. He had a gun. But without these instructions, the jury can say, all right, well, Francois had a gun, so there was mitigation, but Cantor didn't have a gun. The only thing that would allow Williams to shoot Cantor is that he saw Cantor bending down and he believed that he was going to come up with the gun. So when the jury's considering this, they're saying, without knowing, okay, a mistake, if it's a mistake, it can still be self-defense.
So even though the gun is pointed at him at Francois, and he doesn't need a mistaken belief with Francois because Cater, he shoots him and he kills him.
Right,
This mistaken belief issue.
right, that's right. It goes to Cator who died. So that's the murder conviction.
Kador, how many bullets went into Kador?
I think 7.
And did some of them go into his head?
I can't recall
I
exactly.
thought there was some evidence that bullets went through the headrest.
Yes, there was.
Okay, so, and all of the bullets ended up in the 2 people except for 1, correct?
Correct.
So if some of the bullets went through the headrest, I would have assumed they went into Kador's head.
May well be.
Okay, so how does that all fit in with this? He was ducking down.
Well, he saw him ducking down, and then he must have come back up. The shooting started of Cator when Williams believed he was going down to get a gun. So it's not necessarily that there was nothing that said he didn't get back up before the shooting occurred, or maybe he was bending down and the shooting occurred and he got back up and more happened.
So was the defense theory what was the defense theory as to which person got shot first?
I don't believe there was.
So what's the theory now? That he shot at Kador first, or he shot at?
Well, I think he shot at both sort of indiscriminately. He thought that they were both a danger to him. And with Francois, it wasn't a mistake because he saw the gun. And that's apparently what the jury found in finding the lesser included offense.
Doesn't he say he's exiting the car? The car stopped sharp.
He said that he was still in the car, but some evidence said that he exited the car because shells were found outside. But either way, let's say it's excessive force in self-defense, he thinks these 2 guys have guns, and I think it's reasonable to think I can't run away, far enough away so I won't get shot by these 2 guys who have guns, even if I'm outside the car. So, I was trying, I'm trying to think, like, how could they have come back with a lesser offense for Francois and not for Cator? And this perfectly explains it, because they didn't realize that they could consider if there was a mistake. And the same thing, I didn't read the missing instruction from the duty to retreat, but that said, a person must retreat unless he reasonably believes he cannot safely do so. A person need not place himself in danger or use every means of escape short of death before resorting to self-defense. So that would have told the jury that even if they believed he was outside of the car, if he had a reasonable belief that it was not safe for him to retreat, and then they asked that question about self-defense and retreating. So we know that the jury was focusing on that part of the instruction. I see that my time's up. If there's no further questions, I refer you to my brief. Thank you.
Okay. Attorney Weisgold Johnson.
May it please the court. Good morning. My name is Melissa Johnson. I'm an assistant district attorney in Plymouth County on behalf of the Commonwealth. I'll start with the last issue first, since it's fresh in our minds. And I just want to clarify for Justice Wolahojian, the victim was not shot in the head. I believe Cater was not shot in the head. He died because he was shot in the aortic valve here. So it was all over the arm and the back, down into his aorta.
So am I wrong about the headrest?
The headrest was pitted with bullet strikes. You are absolutely right. And what that really says is that this defendant, there's really no doubt that he was standing outside of the car when he shot the victims. All of the shell casings were outside of the car. The door was open. You can see on the surveillance footage that the flashes are outside of the car. And he's pointing the gun down into where the victims are seated. Okay, so that's why there was a downward trajectory from the outside of the car.
So that wouldn't be inconsistent with the hypothesis that the defendant saw Cater reaching down.
The problem with that hypothesis is that the car was geared in drive when the victim was removed from it. So he was still driving the car. He may have cowered when the defendant started firing at him, but there's no evidence to suggest that he was actually reaching down, other than the defendant's own words. It just doesn't seem possible.
We have to take it in the light most favorable to the defendant, though, right? So we have to take that, in terms of whether he gets the instruction or not, we have to take that fact into account, right?
You're absolutely right. And he got the instruction. He got a self-defense instruction here. I just want to remind that there was no specific request or no specific objection to the part of the instruction that he is requesting now. So we're looking at this from a substantial likelihood of miscarriage of justice. I just don't see where we get there when we have actual cases such as Glass, such as Poloquin, that I cited in my brief, where it said that self-defense instruction, it's enough to convey that the notion that he had, he could actually.
Are those SJC, at least one of those is an SJC case, right?
Pike is an SJC case where we talk about the duty of retreat unless reasonably believed not safe to do so. Pike is at 428 Mass 393, and Glass as well, which is the mistaken but reasonable belief instruction, is likewise a SJC case at 401 Mass 799. So yes, this court has spoken that that is enough to convey those concepts that the defendant is complaining about today that he didn't request or object to, I should say.
The escape one is a little troublesome because the jury asked the question, right? They asked very articulately if he's trying to escape and he can't, they basically asked the instruction, right?
I agree. They asked it, and the judge essentially, if I recall, re-instructed them on self-defense. And I just have to point this court to Pike, where the actual words were, the judge instructed that the Commonwealth must prove beyond a reasonable doubt that the defendant did not use all proper and reasonable means under the circumstances before resorting to deadly force. That is enough to convey that. Of course, we now have a specific instruction as to that fact. But at the end of the day, the jury's going to look at that evidence, know that the defendant is standing outside the car, his girlfriend's car is feet away. He's pointing that gun. He's standing outside the car, pointing that gun at the victims. So he had plenty of room to retreat.
The defendant's testimony is right that Cater stops sharply. Francois is surprised. He uses this as an excuse to get out, and then he starts fire. Isn't that sort of what he testified?
He testified to that, but that's not borne out by the physical evidence. He stopped shortly because the defendant was shooting at him, essentially. So, the car's still geared in drive. So I don't think that the physical evidence really bears that out.
So how, in the Commonwealth's view, do you reconcile the lesser included offense determination by the jury with respect to the victim who survived and the first-degree murder conviction with respect to Cater?
Well, we don't necessarily have to reconcile or try to divine what the jury was thinking, but if I had to guess, they were just trying to figure out, because Francois wasn't there to testify, there was evidence that he'd executed an immunity agreement with the Commonwealth, although that was after his statement, so I'm not sure how much weight that bore, and that he had actually admitted that he had a gun. And I think the jury was just probably struggling with that concept, despite all of the overwhelming physical evidence, medical evidence, surveillance footage, CSLI footage, consciousness of guilt evidence that was against this defendant. I think they probably were struggling with that, if I had to guess. It's hard for me to divine what they were thinking, but that sort of brings me to the first issue of Francois' statement. I don't know if that answers your question.
Well, it does in part, but it seems to lead to this idea that if it was based on Francois having a gun, that why then doesn't the mistake instruction become more important?
Well, I do think eventually it does become important, but at the time that it was offered, I think it was the judge's discretionary call to decide, is it probative or is it not probative? Is it relevant or is it not relevant? I mean, a judge could have admitted it at that point. He could have admitted it after the fact, after there was some evidence of self-defense. That's a discretionary call.
Oh, I'm talking about the instruction, sorry, not about the decision to introduce the statement. I'm talking about the lack of a mistake instruction.
Well, I think, number one, it was never flagged for him by the defense attorney. And that really, you have to give the judge the chance to get it right. And this defense attorney did not do that. And then we have the fact that, so now we're looking at substantial likelihood of miscarriage of justice. And we have the Glass case, which is saying that that is enough. That's enough to convey that concept of mistaken and reasonable, or mistaken but reasonable belief. Pardon me.
If the jury is following the instruction accurately, does that mean they bought the self-defense argument? I know you've got plausible things, but if they're following the instruction and don't do intent to murder, did the instruction incorporate the self-defense? I haven't read the instruction.
Well, I think that basically with the assault with intent to murder, assault with intent to kill, I think basically the judge is instructing, if the Commonwealth does not prove beyond a reasonable doubt the absence of mitigating circumstances, that could mean excessive force in self-defense, it could mean sudden combat or provocation, it could mean a lot of things. And that's why it's difficult for me to divine exactly.
There are multiple possibilities besides self-defense.
Yes, Your Honor. So it's difficult for me to divine exactly what the jury was thinking in terms of that. I think that they had heard evidence that there was a gun out there and wasn't sure really what to do with that. But getting back to the first issue, again, it was a discretionary call on the part of Judge Gordon. He could have let it in the evidence then. He could have let it in later when he heard evidence of self-defense. I think it's a discretionary call. Either one would have been reasonable. But what would not have been reasonable is for him to admit the statement without that part of the statement that was sandwiched in the middle where Francois said, but it was after I shot, after the shooting that I threw away the gun.
Can you say more about that? Because I just want to make sure I understand. I know you say it's verbal completeness,
Yes, Your Honor.
but is it actually necessary to understand? I mean,
It is absolutely necessary to why he's admitting that he is possessing the gun and then what he did with it and why he did that. So I do think it's necessary, but even more than that, I think it's misleading, or it would be misleading to the jury to just have one small portion of it without the qualifier, trying to basically clarify what he meant by the possession. So in that sense, it really is no different from the Creighton case or the Aviles case, where you can't just take one part of it, because that would be misleading to the jury. And again, this is a discretionary call on the part of the judge, and I would liken it to the judge saying, okay, maybe there's this minimal probative value here, but the risk of unfair prejudice to the Commonwealth is so great without that little portion of it that it doesn't go in. It has to all come in, all come in together. And that's his discretionary call.
does it matter that it's self-exculpatory?
It doesn't, not necessarily, and I think Desjardins, I'm going to pronounce it wrong, Desjardins talks about the fact that there are portions of a statement that may be less inculpatory, but it's within the judge's discretion to kind of take a look at the entire statement and see if under the meaning of the whole statement that it would be misleading without putting that part in. And that's what Desjardins, I'm going to pronounce it, that case says, is that it's really within the discretion of the judge to determine what portions of the statement must come in. So it's true, there are portions of the statement, I think it's all inculpatory, frankly, but there are portions that are less inculpatory than the others. But I do think that that middle portion of the statement, it is a clarifying statement. It's necessary to understand the entire statement, and it would have been misleading to the jury. There would have been a risk of prejudice to the Commonwealth. It would have been an abuse of discretion for this judge not to let that portion in and yet admit the other portions.
So you do know the record, I think, deeply. Can you tell me, at the time this was argued, what was articulated to the judge of the risk?
So the relevance portion, it came in a little bit messy, for lack of a better legal term. There was first a motion in limine, a written motion in limine, where the defendant had wanted the entire statement in based on the hearsay exception of statement against penal interest. When they came to actually argue the motion, which I believe is in volume 3 during jury impanelment, the defense attorney kind of dialed it back and said, well, I want the whole thing except for this little portion. And so the Commonwealth was like, well, wait a second. I thought we agreed to the whole thing. And then there was a discussion about what I had just been talking about. So the relevance portion, I think Judge Gordon sort of got to towards the end of that discussion, where he was saying, well, I don't see how it is relevant at this point. And it's incredibly misleading, which to me is a signal that he's sort of trying to figure out, is it relevant? And if it is, does the risk of prejudice, of unfair prejudice, outweigh its relevance? So there was a discussion of this. I know you had asked whether there was a voir dire or anything like that. There was nothing like that. It was just simply an oral argument.
Well, I asked about the question about getting the self-defense instruction, at least with respect to this. You're using a lot of terminology that would have been part of a discussion of the risk of unfair prejudice versus the probative value. So I'm just trying to get at, what was the articulated risk that the government was arguing against only admitting 1 and 3 and not number 2? What was the risk to the Commonwealth if statement number 2 were not introduced with 1 and 3?
I think what we were arguing below is essentially verbal completeness, and the fact that it would be misleading to the jury to only have the first. Judge Gordon divided it into 5 parts. The first and the third part and not the second part. It would be misleading to the jury because then they would assume that Francois had actually used the gun when there was no evidence of that whatsoever. And we know from case law, from Espada and from Taylor, that just mere possession of a gun, that's not.
If there had been a bullet shot, would it have been an abuse of discretion by Judge Gordon, not to allow this in? Seems like it's a lot harder. If we had a casing from the other gun, or we had, then then it gets dicey, right?
Well, I think it's a closer question. You're absolutely right. I think there is a little closer question there, but there was absolutely no evidence.
Then it gets a little closer because this bullet there's something stuck in the gun and jammed in the gun.
True,
So
but there
it does
was no.
suggest that it may have been fired. So it's a little closer maybe than it looks, right?
Well, there was no actual round that was discovered in the car. And, by the defendant's own testimony, and he's the only one that actually could testify to witnessing this event, there was a slap or a shot that was inside the car. And so one would expect there to be a round. And this car was searched by both our personnel as well as the defense expert, and nothing was found. There was no evidence on the shot spotter, and there was no evidence on the surveillance footage from any kind of flash or anything like that. All of the spent casings were .40 caliber, which was not associated with the .25 caliber gun.
Thank you.
If there are no further questions, I would rest on my brief. Thank you so much.